Welcome, Adam. Bill.
How we doing?
Hi, Ann.
Hey, nice to see you.
Nice to see you again.
And do you know where they rescued those 27 German Shepherds from in Swansea today?
No.
Humane Society went to somebody's house and did an animal welfare check and took 27 German Shepherds from a puppy mill
That's insane.
in Swansea. We'll find out who it is.
Let's find out who it is.
Yeah, because the Humane Society is looking for money and other help. Relocation. Well, shots and immunizations. That does it. 27.
Yeah. All right. We'll pick up that conversation
Later.
It's 7 p.m. We'll call the meeting to order of the Swansea Zoning Board of Adjustment for October 17, 2022. I'll ask everybody to call the roll and read our agenda.
Pete Tebow.
Here.
Adam Mulhern.
Here.
And Karazinski.
Here.
Brian Lickers.
Here.
Bill Hutwalker.
Here.
Wayne Lechleiter.
Here.
Jay Ward.
Here.
Eric Callio.
Present.
Thank you, Eric.
Eric, could you let us, for the record, know where you are and whether there's anyone with you?
I am alone in the room. I'm in Vermont this evening.
Thank you. Sorry.
That's okay. The Swansea Zoning Board of Adjustment meeting of agenda of October 17, 2022 is as follows. The meeting is to be held on Monday at Wickham Hall, 17 Main Street, Swansea. Public may also access the meeting via Zoom by going to www.zoom.us, using the Zoom app, or by calling 929-205-6099 and entering meeting ID number 235-370-4380. More information on public access to the meeting is available on the town's website at www.swanseanh.gov. Minutes will be reviewed for September 19, 2022. There'll be a review for a regional impact vote, followed by public hearings. The ZBA 22-005 variance application. Francis Macri of Maple Hill Nursery has requested variances pursuant to Section 3, Article 5. Is that 5 or S?
No, there's an S in there.
And 5? S. Oh, it is S. Okay. Articles S3 and S13 to place an off-premises sign at property owned by FTP Real Estate, LLC, on 2 Sprocket Lane. The subject property is shown at tax map 51, lot 1-11, and is located in the commercial industrial district. Other business, rehearing request from Avenue Development Group LTD for ZBA application number 20-003, and any other business that may be required.
Thank you very much. Our first order of business is our minutes from our September 19, 2022 meeting. Everyone who was at that meeting in September are present here, and Brian, Adam, Eric on Zoom, and Wayne. Those minutes have been sent out previously. We'll obtain a motion on those minutes.
Mr. Chairman, I make a motion to approve the minutes as so written.
Thanks, Adam. Do you have a second?
Oh, second.
Thank you.
And it's been moved by Adam, seconded by Ann to accept the minutes as presented. Any questions on the motion? Any edits to the minutes? Any updates or changes that you'd like to see? Hearing, seeing none. All those in favor of approving these minutes indicate so by saying aye.
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 Opposed? No. We do have one public hearing and a hearing request on the agenda tonight, but we do need to take the vote relative to whether either of these hearings or orders of business that we have to take care of rises to the level of having a regional impact. Anyone have any questions or ideas on this?
Mr. Chairman, I make a motion to state that there is no regional impacts, or this is not, either of these applications will rehearing request rise to the level of regional impact.
I'll second that.
It's okay. It's been moved and seconded. I will want to note that, see, tonight we have our full board, literally. Myself, Adam, Brian, Bill, and Ann are seated this evening. Any question on the motion? As well as of the regional impact? Hearing none, seeing none. All those who agree with Adam's motion, that nothing here rises to the level of regional impact, please indicate so by saying aye.
Aye.
Aye. Abstain. Okay.
Who abstained? Was that what?
Bill.
Bill abstained.
Okay. On to our public hearing. The public hearing, ZBA number 22-005. It's a variance application. Francis Macri of Maple Hill Nursery has requested variances pursuant to section 3, article S3 and S13 to place an off-premises sign at property owned by FTP Real Estate LLC on two Sprocket Lane. The subject property shown as tax map 51 lot 1-11 located in the commercial/industrial district. As I've stated, proceeded to this will be myself, Adam, Brian, Bill, and Ann. I'll ask Sarah to give us some background on this and what we're looking at.
Well, essentially, currently the applicant has a freestanding sign that's about 12 feet north of where the proposed sign will go. The existing sign is on the property where the signal station is. And this will replace that, but because it's on a different property, it requires a variance. And also, there is already one freestanding sign on the subject property that belongs to FTP Real Estate advertising full throttle, which is an on-site on-premise sign. Maple Hill does not have any frontage on Route 10, so this allows them to advertise the location of their business without that frontage.
Okay. Brian, Francis?
Yes.
How you doing? Thank you for coming out tonight. In essence, Sarah has given us a recap of what we're looking to do. Why don't you maybe fill in anything else that we may want to know about what you're trying to do here, why, where, the other reasoning behind it.
The pictures show
Which we have good.
the proposed view site is where the cones are. They can see those going up Sprocket. And what this would do would get the sign closer to the entranceway to Sprocket.
Mm-hmm. Yep.
Many times throughout the year, new customers go right by, turn around and drive up and down for an hour. And when they get in, they lecture us they can't find the sign.
Yeah.
So it's going to hopefully get us closer to the driveway, which they can see it more visibly. The sign that's there currently, it's further back.
Mm-hmm. Mm-hmm. Any questions from board members?
Was the Sitco T-bird there when you got your first variance?
The family, the Robertsons,
Mm-hmm.
Okay.
owned the property, and this sign that's up there now was erected back in 2004.
Right.
And what was your question?
But at that time, so there was a gas station there?
Sitco was there.
Sitco was there at that time.
Yeah.
And since then, I mean, they have quite a large sign. And I came up,
Yeah.
when I drove up Route 10 yesterday when the sun was up.
Mm-hmm.
And I had difficulty seeing your sign until like you're basically looking through the gas station to see this sign.
Mm-hmm.
It's so
It's about
if you move it
30 feet, I think, or so off of Route 10.
right, because you can see it through the gas, underneath the roof and then through, and it's hard to see it.
Right.
So I'm just curious, because the sign is, so this new sign, the proposed sign.
Yeah.
Do you think you have enough elevation to be seen from that side of Route 10? you know, if you're driving from the Humane Society, you think there's enough? Because it's,
There is, so if you're looking at the Citgo station, their sign,
there's
it's
going
going
to
to be
be,
right to the right of it.
okay,
So if you're looking at that, we will be in the foreground.
in the foreground.
Yeah. The owner of Full Throttle, Matt, has put a limitation on the height.
Of the sign,
Yeah, I believe it's 8 feet, 8 or 9 feet.
okay.
So similar to what's there now.
And do you have another sign on the Cheshire Horse side? Is there,
That's part of the industrial park,
okay,
and we have a 1 acre lot off the industrial park. That's why that sign is there.
because that's a little confusing too. I would think if a customer comes in there, they might wonder,
Well, no, we have an exit, we have an
an
entranceway
entranceway they can
off of
get there.
Whittemore Road.
Okay.
Yeah.
You can tell how often they visit. All right.
Thanks, Ann. Any other questions from board members? You, Jay, you're welcome to ask questions.
I have no questions.
Sure.
The outline here of the property lines, whose property is that? It doesn't look his. PT's?
Yeah.
Okay.
So currently it's on the Citgo property
That's right.
and it's going to be moving to Full Throttle's property. And they're not here this evening, so they're the ones that said, okay.
I presume you didn't hear anything from police or anyone
No,
else?
there were no concerns. The only concern was just, which isn't really part of your process, is that your state permit will need to be reapplied for.
And we have been corresponding with them. Yeah.
But otherwise, no concerns.
Is it for a curb cut or for a sign?
Just the sign.
Adam?
Yeah, just a quick question. What, and maybe it's in here, I had a little bit of trouble because we're reading some of the things that were filled out here just because of the copy of the copy and so on and so forth and handwritten. What prompted or what is prompting you to move the sign? Is there a reason behind, you know, the current owner saying that it needs to be moved, or is this something that you're just looking to do?
No, we have an opportunity now to move the sign permanently. We're right where we're proposing it through Full Throttle. Well, LLC, whatever. Yeah, the FTP real estate. Yeah. So we've negotiated a 6x10 plot. That's what the cones kind of measure out. And we're purchasing a 6x10 area that's going to be deeded the right to have a sign. This will allow us closer to the entranceway and alleviates a big concern that one day, since the Robinsons don't own it anymore, corporate owns it, they could just ask us to take the sign off.
Oh, so you don't have deeded rights to the sign now. It's out of your control. The sign.
Well, since the Robinsons sold it.
Right. They sold the property.
That's right. And it's kind of vague about what's allowed on their corporate end of it. I don't know if you know, but the corporation is Worldwide Corporation. So it's a global, yeah, the global.
So when you got your variance in 2004, it wasn't what you're arranging with Full Throttle. You didn't get a plot that would be permanent, that would be deeded to you, right?
We just got permission through the Robinsons to put the sign.
Right. So it's more of a gentleman's agreement.
Yes.
Yeah.
Okay.
No formal agreement, no formal,
No,
as you're setting
no.
forth now, I see where it ends.
Right. So it kind of, there's a carrot dangling with us that we could be asked to remove. So we considered that and started to negotiate with Full Throttle and came up with an agreement.
Sarah, I have a question. Is there a limit signage wise per square foot that Full Throttle has on their property? No.
There is, but the size of Maple Hill sign would fall within that limitation.
Okay. And adding to it the Full Throttle sign would already there. Oh, great. Okay.
I believe there's still square footage left over.
There is.
Other questions from the board?
So it's 4 signs per 400 feet.
It's one freestanding sign per 400 feet when you are on Route 10. If Sprocket Lane were not a private road, then it would be 4. Which is a little confusing, but
Sprocket Lane is private.
yeah. So if Sprocket Lane is considered a feeder road and a municipal public road, then only one variance would be necessary rather than 2. So one variance is because only one sign, freestanding sign, is allowed with the frontage that Sprocket has. And the other one is because it's an off-premise sign.
Not.
Because it's
for a business
it's
that
for
isn't
businesses, yeah.
off premises. Any other questions? The applicant? There's no one on Zoom from the public, is there? Or?
Eric, have you
There are the public on Zoom. He has not indicated that it's a question.
Okay. Those who are on Zoom are able to let us know if you have a question. Bill?
I wonder if you could ask the applicant to just summarize his response to the questions. I couldn't read any of them.
Oh, you mean? Oh, and that's in here? Yeah. Is what Bill is referring to is the application that the actual application that you presented.
Oh, so you have, okay.
It is difficult to read in the copy. Maybe if you had it in front of you, you have your.
Unfortunately, I don't have my glasses. It's just like.
Would you be able to?
So we have to talk about the first page here.
Yeah, there's 4 questions on this page.
Yeah.
Facts in support of granting the variance is in bold.
They're saying they can't. They're saying they can't.
Yeah.
It's a day when you get
legible on the computer.
What's that?
It's legible on the computer.
No.
Okay.
So if someone who has a computer could read it.
Pieces? No.
I don't have, I have to be taking minutes, I keep going back to that.
Modify, oh, this modifies, replaces
We're going to see.
variance granted
Hold on just a minute.
on 2002.
And
Yes,
We may be able to get it off of the computer. We're hearing that it's
I can read
Oh, you can read it?
okay.
it. I think so.
Well, I think
You look for it.
I'm almost there.
You're.
Yeah, the blue is a little bit easier to decipher.
Okay, I'm there.
I'm ready to read.
You
go ahead.
She's got the application in front of her, so a little teal.
Better. Okay, so number 1, granting variance would not be contrary to the public interest because this modifies / replaces a variance granted on May 20th, 2002 for an off-site sign. Sign is necessary to allow motorists to locate the driveway and promote traffic safety.
Okay.
Number 2, granting the variance would observe the spirit of the ordinance because it is a backlot in the commercial industrial zone. It requires signage on the roadside to alert motorists to the location of the business consistent with the purpose of the district to promote commerce. In parentheses, Maple Hill Nursery. Number 3, granting the variance would be substantial justice because granting the variance is integral to settling a legal dispute and because it replaces a prior variance and does not increase non-conforming uses or structures. Number 4, granting the variance does not diminish the values of surrounding properties because the sign will be tasteful and has approval of the owner, parentheses, consistent with signage currently across the street. Number 5, unnecessary hardship. Special conditions of the property that distinguish it from other properties in the area are as follows. It's a backlot that has no frontage on the state highway, and the variance is necessary for advertising as well as indicating the location of the business. A, owing to the special conditions of the property as set forth above that distinguish it from other properties in the area. 1, no fair and substantial relationship exists between the general public purposes of the ordinance provision and the specific application of that provision to this property, because no fair and substantial relationship exists as the district is intended to promote commerce and public safety. It dictates giving drivers notice of the driveways so as to avoid sudden stops and turns. And the proposed use is a reasonable one because it promotes traffic safety and permits the business to advertise its services to the public. And then the following page, if A and B are not established, an unnecessary hardship will be deemed to exist if and only, I'm not going to read all of that part, but under B, the lot lacks frontage on the state highway, the sign would promote traffic safety and commerce, and it is reasonable for a business such as Maple Hill Nursery to have a sign associated with the business. Prepared with the assistance of a New Hampshire attorney.
Thank you. Good, Bill. Thank you. That's helpful.
So now that raises 2 questions. I didn't ask them before because I couldn't read it.
There we go. We already have.
So he said it was a gentleman's handshake before. I'm interpreting what he was saying.
Right.
But here a variance was signed.
In 2002.
Did you find one?
I didn't find it, but I think it's possible I wasn't looking in the correct property folder because there are a lot of signs for Maple Hill Nursery. And I was confused by the application in the initial, we've been working on it since April or March.
Oh, you've been working on this since
Yes, on this application since March.
So that then,
but I have no reason to doubt that there is already a variance on file.
I didn't hear your question.
well, you had said earlier with Ann that there was a gentleman's agreement between you and Tim Robinson.
And Jim Robinson, for permission, but we also got a variance
At that time.
at that time.
Okay, that's what I was wondering, because I didn't get the inference that there was actually a variance included, and I was wondering if there was, were there any conditions or anything placed on it?
And if I understand what you said, is that
We were here, but that was 20 years ago.
the new variance, if it's granted, the agreement between you and Full Throttle is you're going to have an accurate deed that gives you the right to have the sign 6 by 10 for life, for as long as your business is yes.
I believe it's as long as there's going to be any business, whether it's my business
Or some other
or some other
business.
business, right?
And there is no way for you to get that same level of of ownership, if you will, from where the sign is presently with the corporate ownership worldwide. You wouldn't be able, you don't believe you'd be able to negotiate a similar agreement where you could actually get legal ability to use that where you are.
I haven't tried.
Yeah.
This proposed site is closer to Sprocket.
Oh, no, I'm not saying that that's a preferential site. Just curious whether they denied that.
Never.
But, so you didn't bring it up.
No.
Okay, that's fine.
And then it says to settling legal dispute.
Anticipated, right? I mean,
Is there a dispute?
It's not a dispute. Well, it was a settlement. We tried to put a sign. We had a sign up earlier, and then when Full Throttle bought it, he asked us to remove a sign.
Okay.
And we went on to, we were trying to get our sign back up. So it was bickering back and forth, and finally we just settled on buying a piece. And he agreed, and we came up with an agreement.
Fact is, right now, everyone's in agreement. No, everyone's in agreement.
We are, it's all, yeah, the attorneys are good too, it's all legal with it.
And you actually own that 6 by 10 at this point,
he will.
or you will.
If everything goes through, then I write a big fat check.
And then you have actual frontage on Sprocket Lane at that point.
That's right. And whether, and if Sprocket ever sells, whoever he sells it to will have to grant that and honor the.
You'll have to honor your ownership.
They'll have to honor the fact that if they have we have a 6x10 on their property.
Other questions or comments or concerns? Wayne, yeah, okay.
Fran isn't buying frontage, she's just buying that 6x8 easement where the sign's gonna be,
Six
right?
by 10, but
6x10.
but is that is part of that a frontage on Sprocket Lane, actual frontage? Or is it set back?
It's set back from the property, yeah. So,
Okay.
Just like the term
Yeah, I
frontage.
may have used the wrong term, forgive me.
Thank you.
But I saw it looks like, it looks within a few feet of Sprocket Lane, so in that sense, it's,
Yeah, in that sense.
and there are setbacks normally from.
And there's a hill over
to the
here.
property.
When I think frontage, I think it's contiguous with the property.
Oh, I see.
So that's why I want to make sure.
I agree with you.
Wait,
And you've already asked the question, but I need to just fix it out of my own head. But there was a variance, at least we're under the impression the variance was made and provided for this particular sign that currently lives by the zoning board of 2002 to 2004.
I'm trying to jog Bill's memory because he'd only been on the board 10 years at that point.
2002. And we don't currently have a copy of that or still record of that that
I
we're
don't
aware of.
remember, but that was before my time also.
Okay. I'm just trying to channel the wisdom of the 2002 ZBA board
there wasn't much.
to understand, how we would approach some of these questions, because these questions were asked at that point as well.
And Sarah wasn't even born yet, so we can't ask her.
So, okay,
That's right.
but we do know that the ZBA at that time, we're assuming, we're able to answer these questions appropriately.
Right.
Okay.
Without condition.
Without condition, are you aware of any conditions or anything that were placed on the variance?
No, I mean, they gave us a variance to set the sign where it was, where we proposed it. And they gave us a variance.
And it's been there ever since.
It's been there ever since.
Yeah.
And you're gonna remove it from
It gets removed.
as soon as the board.
Yes.
And the new sign is not as tall, is that what you said?
That it's smaller. It's can't be any more than 24 square feet. And I believe what's there now is 32, I think.
Yeah.
So it's going smaller.
I'm sorry, for the record, what did you say?
24 square feet.
24, thank you.
Which is the max you can have.
That's the max we can take.
So you're complying with that part of our ordinance.
Yes.
Great. Anything else? Brian? No? Adam?
I'm just trying to anticipate some of the questions here and how they may need to be answered. One way or the other.
Okay.
Are there, just one more question, are we aware of other lots that are, frontage locked from Route 10 that are commercial in nature, industrial nature on that stretch? That fit a very similar profile to this particular property?
The Humane Society, or it's on, I don't know how much frontage they have, whether they just have a limited amount of frontage, but they have that development. The Humane Society, but they're not Humane Society.
There's a large sign right there.
Because they were given them.
Yeah, I don't think they have any frontage.
I don't think
Just
they
have
do.
that road.
Just the road.
That's probably just a right of way.
There's the dog obedience across behind Guyette's.
Yeah.
I believe have a sign on there. That's a right of way also through Guyette property. So that's.
It's a very tiny sign.
Excuse me.
It's a very tiny sign.
Small. The smaller sign.
It's a sign. I don't
It's a sign.
know.
I can barely see it.
Okay.
I tried to find it. Could you there's a sign there.
And then Maple Hill Nurseries had to sign up on Route 10 since 2022, about 2002.
Mhm.
I would point out that if the variance is granted, you could add as a condition of the approval that the existing sign is removed.
That is in our agreement with Full Throttle. We have so many days, I can't remember, once we put a sign up, a new sign that has to come down within so many days. Also, the state, I talked to the state, is also.
That would be easy to add it. Full motion. Sure. Anything else, folks? Adam? Ann? No. Bill, you good? Okay. All right. This is a public hearing. We don't appear to have any, at least anyone from the public here. I'll state that in the room here with them all. There is a member of the public on Zoom that they have not indicated a desire to talk or make any comments. So I guess that being the case, we'll close the public hearing. Anything to add before we go to the questions? I see the board members or anyone actually? No?
Just point out two things.
Absolutely.
Real quick. I know I've been on the board long enough that we've struggled with signs, off-premise signs before for various, reasons, but this is the first that I'm aware of that's come to this board that already had a previous variance from the ZBA at the time. So I don't know if that helps or provides any assistance to anyone's minds, but it's giving me something to work with.
Okay.
Because I know we've been pretty strict in the past on any of this.
Yeah, oh, we've vetted them quite a bit, particularly off-premise signs. We've tried to be careful with our signs over the years. I think in a good way in our business corridors. I think that's what we're doing right now too. So yeah, but that does give a different context than what we've had before. I guess maybe we've been around too long, but a variance now replacing another variance is. I don't know. I don't remember a case where we've had something like that. So all right. Anything else before we go to the questions? Okay.
Would it be inappropriate to point something out?
Please.
So we don't know if the previous variance had any restrictions on it or recommendations, but one thing that board overlooked perhaps is protecting the landowners for where the sign resides and the people who paid to put the sign up and maintain it all these years. So this is an opportunity to correct that oversight, but we don't have the paperwork, so we don't know exactly what was said. We only know that it was granted at that time.
Right. Okay.
As I'm still trying to learn things, do we have to put in a condition that the state approves to give a permit for the sign? I mean, that hasn't happened yet.
But they have to in the state of New Hampshire anyway.
Right, so it doesn't have to be in what we say because the state's gonna have to take care of it anyway. So even if we said yes, the state would still, if they said no, it's
on their highway.
Right.
Yeah.
We still also have to get a sign permit through the town, and that's
okay.
something that we pay attention to.
Okay.
So it doesn't need to be.
Just curious.
Got what it knows. Good. All right.
Yeah, some of the applications have multiple layers that need to be satisfied. And it's always kind of interesting to see which layer you satisfy first before you move forward or sit still. You will alone sometimes.
Yeah.
But it's a great question because for permit will trigger the question.
All right. So we'll go to the questions. Could the variance be granted without being contrary to the public interest? Bill?
How did we know?
How did we know?
No,
I think Adam's point was right in the sense that it's an existing sign that was granted a variance, and this is replacing it, making it more productive for the business. I think we also would acknowledge that it's a grandfather non-conforming use that's being advertised on a private road, which is pretty unusual. It's,
Put it all together.
it's quite unlikely that a similar circumstance would happen with this board. So given the fact that it's grandfathered, excuse me, and if it does improve the visibility of the sign, as Ann mentioned, and Adam, it would not be contrary to the public interest.
Okay. So you agree that the variance can be granted without being contrary to the public interest. Very good. And
I'm agreeing that it's not contrary to the public interest for the reasons Bill stated, and it corrects an oversight by a previous board.
interesting. Yeah. True. Adam?
I would say yes, echoing, both previous responses, and just say that I don't see the public interest being hurt by or harmed. It's ridiculous. It being harmed by granting this variance. There's a sign existing. It's moving 12 feet to one direction,
Getting smaller.
and getting smaller. So I don't see there being harm. So yes.
Thank you. I agree, particularly for the reasons that Adam put forth. No, there's no corresponding. If we were to deny this, I don't see the public interest being, bettered in any way, or certainly not any better than what we would be denying the applicant. So the public interest wouldn't be enhanced all that much if we denied this. It's another way of looking at it. Okay.
Brian.
Mr. Rutgers.
Oh, I'm sorry, Brian.
I agree with that. We'll agree with that. We'll agree with the wise Mr. Hublocker.
Okay, I'm going to complete that all the way around. I agree as well. Thank you. Thank you. Two, do we agree that the spirit of the ordinance would be observed if this variance were granted? And
Yes, I do. I don't feel like I need to say why, but yeah.
okay,
I'm good.
free to say okay.
Yeah.
All right. Adam?
No.
Oh,
No.
you okay?
Yes.
All right. Adam?
Yes, I'll say that the spirit of the ordinance is being granted because the spirit of the ordinance is really to protect, our frontages from over signage. And in this case, that's not happening. One sign is being replaced by another. And it's a situation that's unique, to say the least, based on all the criteria that Bill had presented on this particular property. So, yes.
Brian?
Yeah, I agree. And for the reasons you stated, but also I'm echoing again what Bill had stated for the reasons for question number one, they're germane to this as well.
Bill?
I agree with Brian.
I'll concur as well. We'll go to question 3. Do we agree that granting the variance would do substantial justice? Adam?
Yes, for the applicant, I think there's an obvious justice that's being done. The applicant wants to have visibility on the frontage. So yes, and I think also, again, it's changing one sign to the other, so there's no injustice occurring to the public at large.
Brian?
Well, as I always have fun with this question, substantial justice, because it's like a cliffhanger in a Stephen King novel. To who? Who are we talking about? To the applicant? Sure. To me, I frankly couldn't care less from my house many miles from.
I think it's an overview, sort of in general.
Yeah, but that's not the way it's worded, right? So it's an injustice for the community, justice for the town, justice for the state. Who gives a rip? But for the applicant, I think he cares, and it's the reasons you stated, we'll do justice for him.
I think, again, substantial being the key word here. I think inconsequential being the opposite.
Right.
This is inconsequential. Maybe we might want to say yeah.
Exactly.
But it is substantial.
Yes.
Okay, Bill.
I agree.
Thank you, Ann.
Actually, I think it does substantial justice to all parties, the town included, because it's providing additional protections for all the property owners. So the town doesn't need to get involved in any kind of dispute.
It's true. Particularly should that corner of the gas station like get redeveloped at some point. This be sort of hanging there. Thanks, Ann. I concur. Do we agree that the variance can be granted without diminishing surrounding property values?
Right. Yeah.
You get all the points again.
I restate, yes.
Yes. So you believe that the variance can be granted without diminishing surrounding property values?
There's no evidence to the contrary.
There you go. Bill?
I agree with Brian.
Ann?
I agree with Bill.
And Adam?
Yes, it just seems like a lateral move,
Okay.
one sign for another.
Okay, we'll do 5. Do we agree that special conditions of the property exist that distinguish it from other properties in the area? And I have a question. When we're talking about the property, Sarah, am I correct in presuming that the property is full floor?
It's complicated in this application.
I mean, or is it the little piece of property where he's buying 60 square feet?
I think it's.
Or is it some other?
I think it might actually be the property that Maple Hill is on. Because if Maple Hill had frontage on Route 10, the variance would not be sought.
Okay.
He wouldn't need an off-site sign if he actually had visibility on it.
Okay.
And it is an unusual parcel. So I don't know.
Okay.
You don't have to agree with me with that.
Well, thank you. That's the context is helpful. So, Adam, do special conditions of the property exist that distinctly agree that it distinguishes it from other properties in the area?
I'm going to put a slight monkey wrench into this.
Right.
There are 2 variances that we are looking at, correct?
Yeah.
So which of these 2 are we doing both at the same time?
That's a really good question. I had that teed up and it fell right off my radar.
I think at least I was under the impression you were talking about
The first one,
the first variance.
which would be, thank you, Section 3, Article S3.
And the first one is in regards to having a second freestanding sign on the full throttle property. Well,
And S13 is
an off premise, a freestanding sign that's for a business that is not on the premises.
so we're sort of seems like
I was under the impression personally that we were speaking about the first of these, which is having an off-premise sign
allowed.
with not the required frontage.
Okay,
That's at least how I was making my, I don't know what everybody else is
I
doing.
appreciate that saying that.
So when this goes through to you, is it 2 separate permits or is it 1 permit with 2 clauses?
Just one permit. We look at the whole ordinance for every sign application.
But we need to look at each variant separately and so on.
So for the record, which variance are we addressing right now?
I'm going to check on that right now with the board members.
I think I agree with that, but that's the second one that Sarah mentioned.
You kind of combined both of them actually in your statement.
Oh, well, I guess what I'm referring to is the first variance. And we'll read it specifically. Which is, I just want to get the correct wordage.
Seems to me that our discussion was all about the front of the sign. We didn't mention, at least Sarah, nobody mentioned 2 signs within 400 feet. So I think what we've been discussing is the second one.
I see. S13.
The commentary had to do with off premise.
Yeah.
And making
Not 2 signs within
their 400 feet. And the whole idea of establishing the uniqueness of this property with an off-premise sign.
I thought we were doing both because we were just replacing the sign. But I'll go whatever the board
Yeah, I'd
decides.
be in favor of just doing both.
Me too.
I feel like we're talking about updating a variance from 2004 to accommodate
2002.
it's 2004, right?
No, I said four.
Two.
It's two.
Two, fine, okay, so we're updating a variance to meet the current needs of the land of the property owners.
in our ordinance.
2 of 3 of which have changed hands.
So might I propose that we continue with the questions like we're doing this together, but then when we vote, we actually vote separately. Take one variance and then take a separate variance. We have to vote on them separately anyway. But we're doing the questions, I think, is together. It's the same arguments for both.
Are you, I know you've been focusing on one of the variances all the way through the zero.
I think they kind of hand in glove with each other.
We do, yeah.
In terms of, what the applicant's asking for. But I was just curious in how we were voting. Typically, we take a single variance and then we vote on that going through these questions. I didn't know if we're going to try to repeat that for both.
We could do both.
Or are we taking both variance questions up in these questions and then we'll vote separately on each of the variances?
That we can do that. We can vote separately.
Okay.
I think that we can make
Just to make sure that we're
we can make
covering T's and I's.
You're the boss.
I'm having a hard time following you. Beverly's got it though.
Okay, good.
and every word of it.
I don't know.
So the idea would be we'll consider.
I want to be clear, but what I'm saying is that typically we have every variance and every that is brought to us by an applicant, we have to vote on. And we go through the questions specifically for that variance. In this case, we have 2 variances that we have to go through. Are we going to try to go through all these questions for each particular variance and then vote on each one of these variances? Or are we going to combine the 2?
I get the sense
the
that
questions and then vote specifically on each one separately.
I get the sense that at least Anne vocalized that she had both variances in her mind when I was going through it. I don't know whether that's
In fairness to you, we can do it your way.
Okay.
vote on each of them.
I think we have to
Take 2 votes. Take
2
2
votes
votes.
and go through the questions together. Okay, I'm good with that.
I'm good with that.
Okay.
Okay, so just so I understand, you're going to take both variances in your discussion period. And at the end of that, when there is a motion to either grant or deny, you're going to separate the 2.
Right.
Okay, just want to make sure I'm
Okay. All right. We're back to.
We're going to say something.
Were you gonna say something?
Keep it separate from the beginning.
I just think since the question came up, Keith, you might want to consider going back through the questions. Because we've not had any discussion with regard to 2 signs within 400 feet. All the discussion was off premise, moving it 10 or 12 feet.
Okay.
And if, not that anything's ever going to come of it, but should it come of it, I don't think we can demonstrate that so far we've discussed 2 signs within 400 feet.
Okay, so what I think Bill's saying is that we follow through with what we have going here, presuming that this is the variance for the off-premise sign, and then we can run through the checklist again for having 2 signs within 400 feet. We can, and then take a separate vote on that. I think I'd rather do
that works for me.
That works for you. Okay, because we were on
Okay,
number.
so this one is, the one we've been doing is which?
3S13 offsite.
S3. Isn't that S3?
No, it's 13.
S13.
Okay.
That's what we're doing right
Yes.
now. Okay.
That's what I think we're doing.
Yeah, I believe that's what I had in mind.
That's the offsite.
I'm up for that.
Offsite.
We're almost there.
Okay.
We're
So
almost
are you
there.
going to go through the questions again?
We are going to go through the questions again once we finish.
Oh, okay. So the questions that have been answered and responded to thus far all pertain to Article S13.
Right.
Am I right?
Right.
Section 3,
Okay.
Article S13.
Okay.
Yes, section 3. Okay, got it.
Okay. So we were at 5.
You were at 5.
Right. We're gonna go to Bill. Do special conditions of the property exist that distinguish it from other properties in the area?
But there certainly are, but I'm not sure. What does the deed say with regard to access? You know, off the top of your head.
No, I do not know off the top of my head. I'm sorry.
But it's a landlocked parcel. which is different than the other parcels. It's different than the corner lot. It's different than FTP, both of which have frontage. This is a grandfathered non-conforming use on a landlocked parcel. I think that's unique.
Because that road is privately owned by the homeowner there.
Right, an additional.
I believe that, yeah, the property itself.
Yes.
She's chopping it a bit here.
Chop it back.
Yes.
Yes.
Yeah, okay.
Yes.
Another.
Said a lot of stuff.
All right, Bill agrees that,
Okay, got it.
Bill has agreed that special conditions of the property exist that distinguish from one of the properties in the area. We'll go to Ann.
And in addition to what Bill has stated, this property is going to have a 6 by 10 foot lot, which might be the smallest deeded lot in Swansea. Not?
It will have deeded right of use.
Oh, yes.
Not a fee.
Deeded rights of use.
Which
But
is-
that's got to be the smallest deeded right of use in Swansea. Maybe. That's unique.
Okay. Adam?
My uniqueness quota has been satisfied, so I would agree with both Bill and Ann.
Brian?
I agree with that. Bill agrees with Bill and Ann.
Okay, so I also agree with the special conditions of the properties that distinguish one of the properties in the area as such. Owing to the special conditions of the property distinguishing it from other properties in the area, do we agree that there is not a fair and substantial relationship between the general public purpose of the ordinance, in this case, which is off-site signage, and the specific application of the provision to this property? Ann?
Yes.
Adam?
I would say yes as well, and just citing back to the special conditions of the property itself and what we've stated already about the variance and the spirit of the ordinance being met.
Okay. Bill?
Yes.
And I agree. And lastly, possibly lastly, do we agree that this proposed use is a reasonable one?
You get Brian.
Oh, Brian, I'm so sorry. Because you right next to the voice.
One more time, I agree.
Hurt my feeling. All right, Brian, we'll
Get one left.
Here's your safe space.
Yes.
yes, thank you. And I
Felt bad.
I know, knock me up.
Maybe start with
Upside the
him.
head.
Maybe
That's
start with
a-
him this time.
Well, I'm gonna give him this one. And do we agree that the proposed use is a reasonable one?
Absolutely not.
Okay, moving on.
No, yes.
Thanks, Brian. Bill?
Yes.
And
Yes.
Adam?
Yes.
Thank you. I agree. So as such, we do not need to go on to B, 5B. Here. Having gone through the variances, questions relative to the off-site signage being allowed. Entertain a motion.
I have three things just to ask the board to consider.
The board. Okay.
Well, one, as part of the motion, one of the conditions being that we have a document from the owner indicating that they're aware of and supportive of this.
The owner of full throttle.
FTP, yeah, of FTP.
They wanna own
Because we, unless you've got
Full
something
throttle.
already.
They've signed the sign application.
I
And
saw
I
the
believe-
I saw the signature here, but I don't know whose signature it is. And do we as a practice?
It's Matt Velez. We have spoken with the property owner.
So you're comfortable with that? Okay. That we have a copy for the file of the deed restriction once it's exercised. And the one, I forgot who mentioned it, that the other sign be removed.
Just with the deed restriction.
Or whatever the easement.
Okay.
Because that'll be a transfer that should be recorded.
Okay. So that's a motion. Bill, with those, is that what I?
Sure.
Okay. To approve with the additional information. Do we have a second on that motion?
You appreciate.
I'll second that.
It's been moved and seconded to
I think they have it all.
approve S13 variance. Any questions on the motion? All those in favor indicate so by saying aye.
Aye.
Aye. Opposed? All right. We'll run down through the questions with the variance in mind of having two freestanding signs within 400, no,
400
within
feet.
400 feet of one another.
Okay.
Okay.
And of the four criteria that's in this section of the ordinance, is that the only one that we're really talking about? That's it? Okay, thank you.
So. And just go at this again. So the second one, the second one for S13 having two signs within 100 foot of one another. Do we agree that the variance could be, this variance to do this could be granted without being contrary to the public interest? And
Yes, I think we can grant it without being contrary to the public interest because the sign's actually getting smaller. And they are, I know they're two businesses, but the use of it in that 6x10 side portion, I see as somewhat connected to the property in the back by deed. So the use of it.
use of it. Okay. Adam?
And I'll just add to Anne, I agree. So yes. And I would say that the actual current sign that's there is already a present fixture in people's, the public's knowledge and driving back and forth. So there's not a significant shift or change to what's already there. So I don't think the public interest will be impacted as a result.
Thank you. Brian?
Before I answer, just point of clarification, you said this is for S13. I want to make sure she's got it right here. But
It's
this is
great.
S3. This is S3.
Yeah.
Okay.
Thank you.
Go, my answer is yes.
And Bill?
I agree with that and Adam, yes.
And I will concur as well. We agree that these, if the variance were granted, the spirit of the ordinance would be observed. Adam?
I'll say that the spirit of the ordinance is being observed again for a similar reason. That there is an existing sign that is pointing people towards this particular business. And it's not a significant change to the location physically, even though it's going to a separate property.
Within 400 feet.
Within 400 feet. And I think the ordinance is, the spirit of the ordinance is to reduce the amount of clutter of signage and so forth on roads in our community. And that's not happening in this particular instance.
Thank you, Adam. Appreciate it. Brian?
I agree with that.
Bill?
I agree with that.
Ann?
I agree with Bill.
Okay, and I would concur.
Again, you get left out. Sorry.
Okay, do we agree of granting the variance to have two signs within 400 feet of one another on the same property do substantial justice? Brian?
In this particular case, I do. Sign that's there can't hardly be seen anymore when trucks are parked and pumps and the fact that it sits on Global's property, but not his. Somebody else bought a piece in between, and the road's owned by a guy that hasn't put something on the hill. I think for all of those reasons, the answer is yes.
Well, most of it.
Oh, very good. All right, Brian, thank you very much. Bill?
I agree with Brian.
How can I? Ann?
I can go home now.
Yes.
Yes. Thank you, Adam.
Yes.
And then I will concur. 4, do we agree that the variance can be granted without diminishing surrounding property values? Brian?
There's no evidence to the contrary. So yes.
Thank you. Bill?
I agree.
And I agree.
Adam?
Yes.
Very good. All right. Question 5, this one actually could be answered probably in both cases, but do we agree that special conditions of the property exist that distinguish it from other properties in the area? Bill?
And in this case, Sarah, we're talking about
Full throttle.
Full throttle.
We're talking about full throttle property.
I believe in this case we should, because the two signs are on that property.
So
I'm sorry, are we talking about the nursery property or the other property?
The other.
The other property. Oh,
Full throttle.
okay. Is there a way to identify that?
I mean, it's separate and complete.
Yeah, point by one.
That's where one freestanding
Full throttle. It's the.
Oh, the full throttle, okay.
for every 400.
If you,
I don't have a problem direct because it's a different
access to
business. They're
I believe that's how it's.
they're basically selling the rights.
Plus, in this case, they have
I don't have a problem.
They have.
Hold on a second.
they have like a radio that's 400. You care over 800, right?
No, full throttle has like
For special condition.
On both sides of the driveway.
No.
they don't have much on the north side of the driveway.
That's a gas station. That's cheaper. Yeah. This is full throttle spot.
The aerial view doesn't actually.
This is all.
From that corner to the other corner. So from here, from there to there, it's just over 400 feet. Oh, okay.
This is full throttle. So that's the one. They don't have the other side. Yeah, special.
I don't know this for certain, but I assume that full throttle owns the road because they named it.
It's their property.
Yeah, that makes it even not real. But I don't know that they own it. I'm just assuming that they named it. You know?
So they own it, and then when it turns into my property, then I own it until it goes into Yale Forest and the Chickarins, then they own it, but we all have the right to pass it, free pass.
That makes it sort of
Offer.
unique, right?
So
Good enough for me.
So
Answer that question.
It's also unique because it has a little piece of somebody else's property in it.
Yes.
Or easement, it has that easement.
That's even better.
AM?
Yes.
Right.
Do you want to know why it's unique?
Sure.
As has just been stated, the private road is owned by, mutually owned by many, or has rights to by many entities as it travels up through there.
To the back.
None of which belong to the town, right?
That makes it unique. That makes it unique.
So that makes it unique in that respect. Plus it has a little plot where we're gonna have to see some mounts
a stone wall.
and a stone wall.
Okay. Adam,
Yes.
Brian,
Yes.
and Bill.
Is this the parcel in blue?
Yes, the aerial doesn't actually have, isn't updated with full throttle building on it.
Just like it looks so different on our tax map. Are there two different tax maps?
That's what we were just going over here with Katie.
We do this.
Oh, yeah, it does. It goes over.
These are gas reimbursements. Oh, I don't know. What am I concentrate?
I learned a lot.
We'll agree with everyone else. Makes it
Okay. Thanks, Bill. Yes.
Yeah.
Okay, so now we go to 5A1.
Do I have yours?
Yes, I concur. A1, owing to the special conditions of the property distinguishing it from other property in the area, do we agree that there's not a fair and substantial relationship between the general public purpose of the ordinance, no signs within 400 square feet, and a specific application of the provision to the property? I'm going to go to, I lost track of where I was. I'm going to go to you, Brian.
Yes.
Okay. Bill?
I agree, and primarily it's because of what Adam and others have said about it's making a sign that's currently granted a variance It's bringing it in closer proximity to the property and making it more visible.
Happening to be on the same piece of property.
Yeah.
That another sign is on. All right. Right, so a new sign. Adam?
I would say, yes, I absolutely agree with Bill. I mean, there was a board, the ZBA board of 2002, found it their wisdom to grant this variance for the particular sign that's there. This is preventing potentially public concerns, legal concerns, and so on and so forth. So yes.
Ian?
Yes,
Bill? I agree. And then potentially lastly, do we agree that the proposed use is a reasonable one? Brian?
Yes.
Bill?
Yes.
Ann?
yes,
Adam?
Yes.
All right, I will concur. Now, we are considering this is S3, section 3, article S3, given the our answers to the various questions, entertain a motion.
Even though it's a separate variance, would it make sense to mimic the requirements from the first variance, document the owner, restrictions, as well as removal of the other sign? Everything would be in agreement with that.
Sure. Others, anyone have anything?
nope, that's fine, I second that.
So I would say I will make a motion to grant the variance under the conditions that there is a record of the document from the owner, you know, stating this relationship, so that if this property was ever sold, or this was known and understood.
This goes into full throttles. That address.
And secondly, that this would be granted with the subsequent removal of the sign that's now currently standing.
Second of that motion?
Does that fall within?
Second.
Yes, that's what we had before.
Perfect. Second? Anyone? Oh, I'm sorry.
Yes.
I didn't hear.
Yes,
Yeah, and that's second.
I'm looking for a second.
That's,
Thank you,
She's
Bill
not
seconded and I seconded also. All seconded.
We'll take hands.
Okay.
All right, it's been moved and seconded. Any questions on the motion? Hearing none, saying none. All those in favor of this second variance, please indicate so by saying aye.
Aye.
Aye. Opposed? You're done?
Thank you very much.
Thank you for your patience.
To ease your mind, we cannot put this new sign up. The state won't allow both signs to stand. So we talked to them this week, and they understand if this gets passed, that has to come down once this one goes up. We have I think it's I want to say it's a 14 or 30-day period after the new sign goes, that one's got to come down.
Okay.
So thank you very much.
Thank
For
you.
your time.
Take care.
All right, Sarah, what are you doing to us now?
The next is something I'm going to continue my recusal of, and I really have nothing to add or any history here, so I'm going to hand this over to Adam. We're hearing request from Avenru for ZBA application 20-003.
I need to recuse myself as well, but I do have a question, sir, because I read your letter. It's different from what my understanding was. That this wasn't actually granting a rehearing, as it was a conversation between the town's attorney and the applicant's attorney to create a motion that would clear up the record. And therefore it doesn't reopen a public hearing, and that it is something that if the board discussed tonight, they'd have the ability to make a decision tonight.
Correct.
Okay.
Good to see you.
Oh, not yet. I'm gonna sit right over here. I'm gonna pay particular attention to you.
Thank you.
You're welcome.
All right.
To remind everybody that we have Eric on Zoom, so that we will have the ability to have a full board.
And I will not participate because I was involved in some of the arguments for or against this project back when it first came to the zoning board. And so I think I need to sit with Bill. Although I really don't think I would see anything wrong with participating in this. I think to be sure there's never any doubt about it. This particular issue is pretty clear.
Okay. I'm gonna go sit with John, because I didn't feel like no.
As well.
Yeah.
So, Sarah, could you tee us off? Oh, wait.
Do you see, are you going to see anyone for the recusal?
So we have,
We have Wayne and we have,
yes, so let me see
and
that.
Eric, both.
So Eric, we still have you on the phone or on the?
Yes, I'm here.
All right, excellent. So first of all, let's see Eric for Bill
Okay.
and Wayne for Keith. Okay. Sarah, would you be so kind as to kind of tee us off as to what we're being asked to do? And
So essentially, you're being asked to make a statement, a motion indicating that the notice of decision accurately reflects the will of the board at your September 19th meeting, when you had the public hearing, rehearing for Adam for redeliberation.
Could you please repeat that again? What?
Yeah.
The
They say in English this time?
notice of decision reflects the accurate what of the board?
The will.
Oh, the will. Okay.
Well, that's,
Did we not pass it?
did we not pass it?
Yes, you did.
Then that was,
I think it was the second part when Bev read my motion and we opted to take out the salary and the income restrictions and
Yeah.
just go with the 62-year-old and higher age requirements. I think that's.
And that's what was reflected in the notice of decision. That is what was applied for. And so they're just looking for a motion for clarity that the notice of decision reflects the intent of the board.
I was concerned about this after everybody left and then we revisited it towards the end of the meeting. And I was afraid this was going to create some kind of confusion.
Okay, so pardon my ignorance here. So after all the back and forth between the town and the court and the town and the court, and blah, 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 and come back to what we hear, we pass it.
Mm-hmm.
And now they want us to clarify our passing.
They just want no ambiguity at all because.
Given at what point? They have to have a specific point. I'm not at all interested in going back and re-clarifying the entire thing. That's not my-
Just clarifying that the notice of decision reflects the decision that you all made.
Would you have a copy of the
that
notice?
doesn't even make sense in my.
They all have it in their packet. No, yeah, it's in fact.
That makes no sense in my words. I just don't even know what that means. That's,
I think there was confusion over the initial motion that was made and how it was amended. So just to make it abundantly clear what you decided and, you know, just to say whether or not you agree with how your decision was represented in the notice of decision, which is included in the packet. So you can see what I said.
Can you read back what our motion was, please?
The motion,
It's in the
Is that in the-
minute.
Yeah, I'll read it right now for you because I gotta get beat up.
Oh, good.
So the finalized motion, or you want to hear both motions, and you'll see the nuance between the two. So the original motion. Or I had it, no, I lost it.
I've got it, if you want.
Please.
Yeah. So motion was made by me to approve the special exception with condition that the development not be section 8, or be age restricted senior housing for 62 years of age and over with stable incomes, persons earning between 25,000 and 45,000 as defined by the applicant at the zoning board of adjustment public hearing on April 20th, 2020 and recorded in the draft minutes of April 20, 2020. There was a second by Ian. No further discussion. All in favor?
Because that was the initial.
There was initial.
Yep, that was the initial.
And then the second one is, it was amended his motion to approve the special exception for multifamily housing with condition of the development be age restricted senior housing for 62 years of and over with stable incomes as defined by the applicant at the zoning board of adjustment public hearing of April 20th, 2020 and recorded in the draft minutes of the April 20th, 2020. There was a second by Krinsky and no further discussion. All were in favor of the motion passed. The differentiation is the removal of the income.
Which we referred to that they put in their testimony to us back in 2020 in the first place. Is that right?
Correct. The whole rationale behind putting this restriction was this was what we were being presented with in terms of the application, an application for a multifamily use property with these conditions. And I think as a board, we all made our decision based upon that.
Can I make a distinction here? The motion originally was not be section 8.
Correct.
Right.
And that was removed from the last motion.
Right.
Oh, it was removed in the last
Yeah,
one.
and stable incomes is still in there, which was also.
Yeah, but we took the dollar amount out.
Yes, we took the 25,000 and 45,000. I just wanted to make sure you understood
But
that.
there's two differentiations.
Okay, so the 8A is out and the
8
dollar limit is out.
$45, and you just left in stable income.
And that's actually a good point. I did not think that that's what was your motion, Wayne. I didn't know if your intention to remove both.
Not be section 8. That was very
Correct.
clear at the time.
Yep, section 8 in the salary range. Yeah.
Okay.
Or the income range.
So the question comes, are we as a board satisfied that our motion and our will is being communicated?
So I think that
In
From
the
my-
notice of decision, I just want to clarify.
just in the notice of
Just
decision.
in the notice of decision.
Okay, so now we need to read the notice of decision.
That's the thing.
Yeah, I read it again.
That's the one you said.
Yeah.
Here.
So it doesn't say,
No, that's the memo.
it doesn't say stable incomes.
No, I omitted stable incomes because that is not actually a legal reference to anything.
Okay, but I just want to, I just want you guys to know that it's removed.
Yeah, because I had the opinion at the time, and I still have, we're not allowed to put, I don't think we have the right, the responsibility, or the legal obligation to put income limits on anything. That's way outside of our jurisdiction. But I think referencing the fact that the applicant entered it into their testimony and application pigeonholes them, but that's a shame on them. They put it in. We can't stick with it. So you were vague in your announcement, so I just want that.
We just want to confirm that that represents the decision.
I think age restriction was something that was definitely part of this. In terms of the what the use was being committed to us as.
That's the way they presented it.
That's why it was presented. They also presented, the applicant also presented both that this would not be Section 8 housing as well as stable incomes. We did not come up with that language.
Right.
That language was part of the application.
Well, it was part of the testimony, which is different than being part of the application.
I was under the impression it was both.
I don't believe that the application document actually indicated.
I thought
It
they
won't
did.
be section 8, it would be people stay with them, but I believe that was just part of the testimony. During the public hearing.
Okay, I don't have it in front of me, so I can't reference it.
So bottom line, are they looking for us to take a vote that your
So what they're,
clarification is our position, or are they looking for us to make a public statement that you can repost?
They're
Got a
looking
window
for a
back
vote
here.
that the notice of decision is correct.
Is there something wrong with our decision? Because are we being set up for something?
I don't believe so. They just want clarity.
Is 62 and older mean every resident has to be, or just the primary person living in the unit? So they can have a bunch of 16-year-old kids.
I can't speak to that, but I'm not sure that's what this is a
Is
question.
that what we voted on?
62 and over, yes.
That all residents have to be 62.
I don't know if we did, I don't think we said
I'm not
that.
sure that's
I don't think
legal.
we can even make that, because then you get into
Just throwing
discrimination.
that out there. I don't, you know.
Well, right off the bat, I can tell you that I'm absolutely not in favor of a rehearing. The way it's presented is for a rehearing, and I'm a flat no. I don't care what they're bringing to the table. I'm not interested in rehearing.
Well, and a rehearing isn't necessary, provided that there's consensus that the notice of decision is accurately depicting the will of the board, what you decide. You did approve a multifamily use for 76 units, age restricted to ages 62 and up, which is reflected in the notice of decision. So it's really just simply a question of whether or not that's an accurate depiction of the decision that was made.
I'll make a motion that we agree with the notice of decision that was drafted by Sarah to Mr. Franks.
And do we need, and or is it wise to suggest that we also refer back to our motion? No, okay.
No, I don't think we want to do that.
Then I concur with you.
Are you seconding that motion?
I'm seconding that.
Okay.
all right, Eric, did you hear all that?
Yes, I picked up on that. Yes.
Okay, perfect. I just didn't know some kind of Zoom clarity is not 100%. That's good. All right, so a motion's been made to accept that the board's decision on September 19th and the will of the board is being communicated in the public notice as so written, and it's been seconded.
I actually have it written as motion was made by Leclerc. This is what he said, that the notice of decision is accurate as presented. That's what Mr. Leclerc said.
Yes. Okay.
Okay. Is that what you seconded?
That's correct.
Okay, thank you.
All right. Because Eric is in remote land here, Beverly, would you please do a roll call?
Okay, I'll be glad to do that.
I'm sorry, first before I do that, is there any questions on the motion?
Yeah, I have a question for Sarah. Is this going to pigeonhole us? I know you were asked that already. You said you didn't believe so.
I don't.
But I can't believe this is being tabled without an ulterior motive, because it wouldn't be
Should
without it.
we discuss this with anybody that isn't present before we get into this?
I
we don't have time.
discussed the notice of decision with council before it was sent. And council agrees that it accurately depicts the will of the board. I don't believe that the board is being set up for anything. I believe it's really just for clarity of the record.
Okay.
Simply put, just clarity of the record.
Okay.
All right.
Any other questions on the motion? Eric?
No questions.
Okay. Beverly, could you
Okay.
please do a roll call?
Okay, Rogers,
Yes.
Leclerc,
Yes.
Karasinski,
Yes.
Mulhern,
Yes.
Callio,
Yes.
the motion passes unanimously.
Thank you.
Does the 30-day window stay of public discussion, since this was not a public hearing, that has now expired, correct?
It
Has
expires.
their opportunity to challenge or re-challenge?
It expires in 3 days.
In 3 days. Okay. Thank you.
Okay. Is there any other business that we need to discuss or would like to discuss?
I have a little bit of other business for you guys. It's tiny, it's just homework assignments.
Yeah.
You can blame Bill. It's Bill's homework assignment. He went to the land use conference or attended the virtual conference on Saturday. And there was some case law that was, I don't know, pointed to. Do you want to tell us anything more about this? I wasn't.
Did you sit in on the case law? I didn't sit on the case law when I went to the zoning board procedures because I thought I needed more. So in the case law, there were 2 attorneys that reviewed a series of cases, and the 2 most significant cases that we've experienced as boards were referred to as bullshit and simplex, and those all occurred almost 20 years ago, and they completely changed the landscape for variances. I think it was bullshit that split variances off into use variances and area variances. So we wanted to discern what type of variance it was that we were considering. But the main thing that it did was it opened up the opportunity to get a variance. Prior to simplex and bullshit, if somebody had a lot, let's take Grand Rapids, he comes in to apply for a variance to put in his nursery. And he doesn't have any frontage, doesn't have any of this. And he said, well, I can't really use my land. Well, the argument would be you could set up some lawn chairs and watch the sunrise. You've got use of your land. That was literally the discussion. And then when bullshit and simplex came through, it opened the door for more flexibility on the board parts. This case here, I didn't get a chance to read, but the attorney Chris Bowl, who's excellent for land use, strongly recommended that everybody read this case. And apparently, this is case law. It did come after bullshit and simplex. But my assumption from what he said is it does away, or it did away with the use of the area variance distinction. But in fairness, I haven't read it. I just asked Sarah to send it because he strongly recommended that everybody that participated read it. So I figured it'd be something along with taking a look at it to get time. The print is a little small.
It's a little small. I'm sorry about that.
That's a genesis.
And I've also given you a second page and you're like, what is this good afternoon Bill email that I'm getting? This is a memo that Bill received from Stephen Buckley from New Hampshire Municipal about the definition of injurious, obnoxious, or offensive, just for future knowledge as you go through applications for variances or special exceptions or whatnot. So this is a couple years old, but it's always good to be reminded of what that actually means.
I think that's helpful because that's a really hard argument for me to challenge myself with, because what's offensive to me may not be to Bill or Adam, and it could be to Ann, but not to Wayne.
One of the people at the hearing that we had after things had settled, she's in here, and I had talked about pulling out of my property on Pitcher Point and how dangerous it was to pull out. And she picked right up on that and said that, we'll see right there, that's a safety issue. But the safety wasn't of the 2 questions we were talking about that night. So that was already passed. But if people were doing the speed limit, it wouldn't be an unsafe place to pull out of.
Right.
You know, you live up there. Well, you live up there too.
Right.
It's just the traffic is, they're driving well over speed.
People aren't-
Right, but then we have to have a patrol car on
Yeah.
that side of town.
They're just not considered.
Yeah, but I look at,
It's true all over town.
yeah, but I look at that, you can't really apply that to this
Right.
because it's unsafe because of somebody else's action.
Right.
So,
Well, you could say that there's so many people on the road that it makes for more of an issue. Because there's so many people on the road, not the fact necessarily they're driving that fast, but there's so many people there. When I walk down that road, there are lots of people driving. So and if you can't pull out from Pitcher Point safely because people are coming by, so many of them, then that's an issue. But I don't know if that's excessive noise, unsanitary conditions, vibration, vapors, toxic emissions. I don't think any of those are there. So this helps. It helps understand that criteria.
yeah.
It's just interesting. I still think that this gives these words give some level of interpretation to the application at hand. Just because what we're talking about in terms of multifamily unit, where these types of criteria or definition of injurious, obnoxious, offensive, refer to unsanitary, excessive vibrations, vapors, toxic emissions. But there are other uses that people could apply for that could be obnoxious, injurious, or offensive by the nature of those uses that are not these things. So I still believe that there is some flexibility in these terms, and they're vague for purpose.
Yeah.
Because there's certain things out there that, you know, should be really considered heavily before they're allowed. But this is helpful, at least give a frame of reference.
I'll agree.
And I think the Supreme Court very much agrees with these interpretations, as we've seen in our, you know, I've seen in the case that we went through.
I think that's absolutely correct. I mean, if you try to put a mechanic shop on my dead end street, that would be obnoxious, potentially injurious, certainly offensive. But putting an apartment building on a state highway, to me, maybe, but to others, maybe not. So yeah, it's just a good framework.
And to your point, Wayne, just one last thing. I mean, I deal with the same thing. I live on Matthews Road, and I'd say the average speed limit or average car driving, depending on what time it is probably running about 40 to 45 miles an hour. It's a 30-mile-an-hour zone.
Yeah.
And you got people hitting 60, 65 sometimes going across the front.
People die on that road.
There are many, many trees that are missing.
My son wrecked a car on that road, not going 30.
But I spoke with some of the officers in the Swansea Police Department because I had a concern not only with the traffic, but the littering is just insane. I mean, it's disgusting that people do what they do. And one of the responses came back was that there was quite a bit of patrol on that particular road. It's kind of a thoroughfare between parts of Swansea and Keene and so forth. A lot of people use it. And one of the things the officer told me, he says that he has to sit there all of 5 minutes before he bangs someone for 45 miles an hour. He says it doesn't take more than 5 minutes. So it's a known issue. So to your point about people driving fast, if it's just, the desire of one person driving a little bit higher than speed limit, but if it's a known problem that people constantly are driving fast on any particular road, I think that you can take that into consideration for safety and so forth, even though it's the culmination of multiple people's lead feet,
Yeah, or the lack of cop presence. They fly by your house. That's a state highway. I think that's owned by NASCAR, isn't it?
Sure, especially with the paving.
Yeah, and even better now. Yeah, they can actually start to drift right past your house. Yeah.
Actually, look off. Oh, you saw me that? I was late for a tea time. I had a deer run in front of me though one day.
We're fortunate over by my house. Swansea police they're almost never over there. It's kind of a parade when they show up because they're just never there. But the state cop, plate number 308, he's always there now by Sam's. And I stopped over there one day and just gave him a Dunkin' Donuts gift. Said, "Hey, thanks for patrolling the NASCAR highway." Because coming in and out of my street, I mean, you take your life in your hands there. And then he said the same thing. He says you're there for maybe in a rare day, 3 minutes before his lights are already going. Just tagging somebody.
I get a middle finger a week from drivers telling us when we tell them to slow down.
Yeah.
We're walking down, especially with Lake Street.
Yeah.
Well, thank you, Bill.
Thank you.
Be beneficial to all. Help my insomnia already.
Make a motion, we adjourn.
Is there a second to said motion?
I'll second that.
All those in favor? Oh, I'm sorry, we have to do Eric, you still with us?
Yeah.
All right, Beverly, could you please do your roll call vote?
Rutgers.
Sorry, I can't.
He's recusing himself.
Yes.
Kaczynski.
Yes.
Mulhern.
Yes.
Bill, are you back in the meeting? You're not bad.
He's stressing.
Life lighter,
Yes.
Calio,
Yes.
Ward, I think, did come back.
I did, and I'd say yes.
Okay, there we go.
Thank you, Eric.
Just came back so I could vote.
All right, thanks, everyone.
Have a
Have a
good
good
night.
night.
Did something
Yeah,
tonight.
exactly.
So we're driving a